For the topic of this entire seminar, there are a few questions that have to be answered in each case. Is the conduct involved something we want to oppose? Should the government be involved in opposing it? Should that action by the government be in the form of a lawsuit? That was something that was discussed a little bit in the last panel. Should private attorneys be used by the public entities? And if so, how should the private attorneys be chosen and compensated? The topic of this panel seems to focus on the last two issues, but I'm so pleased with this panel. They're all practitioners. We have no academics on this panel. No. I can see the reviews of my next opinion. No, but it's really important to have people who are in the trenches working, and I'm very pleased that that's what we have here. And I'll be giving very brief introductions of each of the panel members just before they speak. And we'll start with Robert Carey. He's with Hagens Berman in Arizona. He's successfully brought a number of major lawsuits, including the largest medical malpractice verdict in 2018 and class actions on behalf of consumers and workers that have been very large amounts. And he's also been on the government side. He's a former Chief Deputy Attorney General in Arizona. So Robert?
Thank you. Well, for motivation, that's in the title of our topic. Let's start here. What Attorney General would not want to be part of the tobacco result or the opioids result? Every single one of them would. That's what they do. They all want to protect the public. They all want to get out ahead, and they want to do things that are historic and epic, and they'll be remembered for. And as I mold the topic over, the real issue is, why aren't these cases going forward? If the attorneys general align with the ideas and the objectives and the goals of these lawsuits, why aren't there more of them? And there's a wide variety of factors that end up discouraging the attorneys general and limiting the circumstances they go forward in. And just to mention a few, there are political pressures that we heard the last panel talk about, and that's not just political pressures on the substance of the suit, but specific political pressure from your supporters. It's from your donors. It's from people who are just out on the street that will become agitators against you if they don't like what you're doing. You'll alienate the business community in a lot of respects. You might end up there out on your own with no other AG joining in the suit if you're the first one bringing this novel theory, and no AG wants that. They don't want to be out there alone. They want other AGs, and that's one of the things you've seen rise up is the multi-states where AGs cooperate a lot more today than they did when I was there in the late 90s and mid 90s. AGs aren't, they're worried about their resources. And you think, okay, we'll take an office like Arizona. When I was there in the 90s, we had 300 and some lawyers. By the time you factor out the federal funds, the program grants, the revolving funds, the agency pay, it's a pretty small office, and these two gentlemen here will tell you that you don't have a lot of discretion. You can't go do giant cases all the time. You might be able to get away with one, but you might end up there and then all of a sudden your resources are drained. You have no more discretionary funding. You're in a case that's outside of your wheelhouse. All of those things conspire to make AGs say no. And one of the biggest ones, and I, again, like Professor Fitzpatrick, I hate to say it to a lot of assistant attorneys general, but inertia is a problem. The staff will come to the attorney general and give him 5,000 reasons why it's a terrible idea to move forward. So typically AGs would move forward when the political risks are low, the substance risk of the lawsuit is low, the facts are sort of developed by either the press or private counsel, and there's some either projected, expected, or actual public support for the claims. So everybody gets on board on VW emissions because it's out there and people are outraged, so it's easy for the AG to get on board on those. But then they get over those hurdles, and they have to get comfortable with the idea of all this discomfort, right, of the conflict that's going to occur when you go take on a big industry that's going to bring in teams of top-notch lawyers, which AGs don't face. They face good lawyers locally, and sometimes they'll have a good lawyer on the other side, but they don't see teams of lawyers coming in with awesome briefs, every brief you could think of is being filed. And the AG starts to worry because they don't want their facts to turn upside down. They don't want their political support to erode. And worst of all, they don't want to end up in a trial in a case they may not understand fully. So I'd like to share with you kind of the risk reward of what I experienced when I was there, which was in the tobacco context. I was at the Arizona AG's office in the 90s when we first went up to Northeastern University. It was one of the very first organizational meetings after the first 2 or 3 states had filed. And my AG was an exceptional guy, perfect for the opportunity that he was going to be presented with. He was a tremendous trial lawyer, and when I say that, let me put some numbers on it. Prior to being elected as the AG, he had had 27 consecutive acquittals of major felonies. Okay, now I don't think that's a great track record to be the state's prosecutor, but that's where he was coming from. And then he was the chief of staff, the very first chief of staff for John McCain, which taught him, don't worry about political pressure, just who cares, just do it. If it's the right thing to do, do it. So that was kind of his mindset. So I went up to Boston and went to the thing, and I came back, I said, we're the only Republican. You do get that, right? Like, it's all Democrats. And he said, yeah, I figured that. And if we don't get on board, they'll think it's a partisan deal. And so he got over that, but I'm sure a lot of less confident AGs would have looked at that differently. And so we ended up going forward, and we got lucky because we ended up hiring a firm. We couldn't do it by ourselves, again, because of the resources and those types of things. And so we ended up hiring a firm that was representing the state of Washington and getting ready for trial up there, which gave us kind of the leverage that we're talking about, this partnership. It gave us the expertise and insights on the evidence and on the theories, but it gave us instant credibility too. So Grant Woods gets over these hurdles, goes and secures private counsel. Unfortunately, they had the lowest bid in the country at that time, so that alleviated a lot of the political risk of retaining them. And then he gets to move forward on one of the most historic cases ever. You heard about the prior panel. They have a lot of questions today about this settlement. And Arizona was not a big state, so we got assigned a company called Liggett. And Liggett's CEO comes down to the Attorney General's office in Arizona to talk settlement. Early on, the whole tobacco thing from start to finish for states outside of Texas and Mississippi was only 3 years. And Liggett's CEO shows up real early and says, I want to talk. Look, we're really a small company. We're a small player in this whole thing. And if you don't cut a deal with us, we're going to file bankruptcy. And then they proceed to do what most defendants do, but particularly a defendant that hasn't lost a case ever. They made an offensively low settlement offer. And Attorney General Woods said, he stood up and he of course planned to try the case himself, and he said, look, you are a small player. I don't care about your money. I view you as the driver of the getaway car for the bank robbers. And he goes, you're going to admit everything, or the next time I see you, you'll be in court. And he walked out. So the private counsel and the AAGs are just sitting there with the Liggett lawyers going, what the heck just happened? What are we going to do, right? Like, we've never seen this. They hash some things out, and soon the private lawyer, Steve Berman, from my firm now in Seattle, rolls in, and the first thing Grant Woods says to him is, wow, we sure shook that up, didn't we, Steve? And that was the beginning of the settlement. That's how it happened. And Liggett confessed everything. They admitted their product was addictive. They gave us exhibits and documents. They caved. And that caused the rest of the industry to cave. And so when you say, what are the motivations for why an AG would want to do it, it's things like that. And they don't all have to be that historic. They can be lesser versions of that, but things you're really proud of, and things you probably, unless you're in New York or California, don't have the resources to accomplish. And it gives the Attorney General the opportunity to do that. And you have a lot of things to get over, but but private counsel can really help. And let me give you 3 reasons why. And it's become a little politicized, much more than when I was there even today, because now they have DAGA, the Democrats, and RAGA, the Republican attorney generals. And that really wasn't a thing back then. It was really more about the lawsuit. And so people would look to the private counsel without the constraints you have today, and you'd look for the expertise that you don't have. And I was in the Attorney General's office as the chief deputy for 8 years. There's some great people there. There's some fantastic lawyers. But the reality, undergirding what Professor Fitzpatrick said, is it's a much more myopic focus for people out there in firms like mine. They can study a novel theory for years and follow the case law across the country and follow all the facts and get it just right. And you can't buy that. It can't be replicated. No matter how smart your lawyers are or how much you want to do it, it's just really hard to do. And it's really hard to do when you've got a case schedule that's confronting you. So you can go out and get expertise. And sometimes people don't do it. I don't know why. AGs don't do it. When my firm was in the Volkswagen emissions case, one of the first things we did when we came out of that, or actually even during it, is we went out and bought these things called PEMS machines, portable emissions measuring systems. And we bought Mercedes cars, a bunch of them. And we hired the best experts in the country on emissions. And we went around and we checked all sorts of cars. And we found Mercedes did it. And one attorney general has done the follow-on case for the state against that company, the state of Arizona, Mark Brnovich, who's speaking later, I think. Where are the rest? They all got a ton of money out of Volkswagen. They all got great publicity out of Volkswagen, but only one has taken that up. But beyond Mercedes, we found GM, Dodge, BMW, Fiat Chrysler, which some states did take action against. But the rest, it's just sitting there. And those are the types of cases that attorneys general need to be alerted to and helped on, so they can easily dip in and go pursue those cases and get an easy, quick recovery for the state. And it's not easy, I don't want to say that, but it's easier because you already have the expertise developed, you know what the facts are, your complaints are super thorough, and you're coming off riding the wave, not trying to paddle up to the top of it. You also get to leverage your office. You get to go out and have your lawyers manage lawyers rather than try to do everything yourself. And I think I'm out of time, but I will say one more thing. Actually, I'll stop. I'm supposed to stop, but I appreciate your time.
They're showing cards up there that show how much time you have left. I couldn't see it until you said that time was up. Unfortunately, it reminds me of a joke my son, a doctor, told me this past week, and I'll share this awful joke with you. But the doctor had just given the patient very bad news. And the patient said, "Well, doc, how much time do I have left?" And the doctor said, 10. The patient said, 10 what? And the doctor said, 9, 8. Trevor Cox is our next presenter. He's at the Hunton firm in Richmond, Virginia. People my age remember that as the Lewis Powell firm. And he told me that Lewis Powell III has the office next to him. He was in the Virginia Solicitor General's office, including acting as acting Solicitor General for a while, 4 years in that office. And he'll give us his perspective on our issues today.
Thank you, Your Honor. It is my honor to be part of this distinguished panel. As a practitioner now, I should at the outset give the requisite disclaimer that while others at my firm may represent clients who face novel liability claims, I'm here today speaking in my personal capacity, and my comments should not be construed as being made on their behalf. With that out of the way, I thought it would be a useful contribution to this discussion to give a quick refresher or overview of the mechanism by which public entities typically fund novel liability claims, and that's through the contingency fee agreement and arrangement that was referenced in the last panel and appropriately deferred to this panel to discuss. And that is, a general term for where counsel's compensation is in some way related to the outcome of the litigation. And I don't think a discussion about this increasing wave of suits by localities would be complete without an appreciation of the contingency fee arrangement and the dynamics it brings, the perceived pluses and minuses that Professor Fitzpatrick mentioned. And then I think it's worth noting how states are responding to that as part of the growing wave of locality litigation. Now, we're all familiar with this arrangement in one context or another, but it is an arrangement that is especially relied on in this area where the legal claims may be novel. And so precisely because a public entity may not want to expend funds on an unproven theory at the front end of a lawsuit where the prospects of success may be even more uncertain than usual. And that, of course, is what advocates say is the main virtue of these agreements, that public entities need not have a bunch of money and staff and expertise devoted to researching claims, filing suit, paying for experts, handling huge discovery burdens. It's plausible, as I think was implicit in the previous discussion, that cities and counties especially, let alone AG offices, simply would not even consider bringing litigation affirmatively if they had to pay for it up front. I think that's pretty obvious. And without localities having to front the costs and take on the risks, proponents argue that these arrangements allow entities, big and small, to participate in large-scale litigation at a relatively limited cost. Depending on the nature of the litigation and the outcome, the public entity would typically receive the majority of the recovery, while 10 to as much as 35% of the recovery would go to attorneys. But the increased reliance by states and localities on contingency fee agreements has also drawn a lot of critics since it became more common in the era of the tobacco litigation. And that criticism tends to fall in two buckets based on one, fairness, and two, finances. First, as to fairness, critics have expressed a variety of concerns stemming from the notion that contingency fee arrangements hand over too much public power to private counsel, potentially allowing private interests to subordinate the public interest. Some go as far as to argue that such an arrangement violates due process. That is not an argument that has gotten a lot of traction in courts, but it has led some courts to lay down principles about the level of involvement that a public entity should have in the litigation and the level of control that the public entity must retain over the course of the litigation, including the terms of settlement. The lead paint case out of the Rhode Island Supreme Court said that, in that case, an AG's office must maintain, quote, absolute and total control over all critical decision making. Critics also theorize that there's a potential misalignment of interests in the litigation in that private counsel compensated through a share of monetary relief may not be incentivized to push for non-monetary terms that may better serve the public interest. Sort of the flip side of what Professor Fitzpatrick was saying. Example, for instance, a simple, probably overly simple example in the opioid context would be you might have private counsel pushing for a solely financial recovery, whereas part of the settlement that a public entity may be better served by would be free doses of treatment medicines from the defendants. So that's fairness. As to finances, critics tend to note that contingency fee arrangement can cut pretty significantly into the recovery that would otherwise go to the public entity or to compensate the victims of the alleged harm. In the tobacco settlement agreement, for instance, the recovery itself was massive, right? Over $200 billion. But the estimates are, I've seen various estimates ranging from $14 to $30 billion went to cover attorney's fees. I haven't done the math myself, but one assessment I saw said that equated to about $10,000 per attorney hour expended in the litigation. And of course, the sheer size of those lucrative contracts is one reason why some unethical attorneys may push the boundaries of what's proper in order to secure those contracts. And maybe that's a topic the panel can discuss later on. Critics also note that some public entities may not be as sophisticated or aggressive in negotiating contingency fee agreements as others, so that you have a wide variation in the amount of recovery that is spent on attorney's fees. There was a recent study done of Texas localities who were involved in the opioid litigation, and the range was from Dallas, which paid over 12.5% or would pay over 12.5% based on the contract they entered into, all the way up to Houston, where the agreement was for 35% being paid over to attorneys' fees. And so you have a potential inequity even among localities. And that's actually a separate reason why some state AGs argue that maybe it should just be the state negotiating on behalf of all the localities and all the people in the state, so you don't have that kind of inequity by jurisdiction. So in response to these concerns, states have taken a number of steps going back more than a decade to ensure that there's greater oversight and safeguards in place. And so as we think about public entities bringing claims, I think it's relevant to keep those in mind. The main strategy pushed by critics has been to bring private counsel more out into the open and to scrutinize the arrangements that are entered into. Numerous states have passed statutes based on model legislation such as the Private Attorney Retention Sunshine Act, PARSA, and TPAC, the Transparency in Private Attorney Contracting, which governs states' hiring of outside counsel. Note the emphasis on states. It hasn't trickled down yet to municipalities in many cases. And then some attorneys general have put their own office-specific guidelines in place. General Morrissey in West Virginia did that with much fanfare a few years ago. And the key components of those provisions are to, one, require that all agreements are made available for public inspection, typically put on a website. Two, to make sure that there's competitive bidding and that the eventual agreement is cost effective, and a certification that the arrangement is in the public interest. And then three, to impose some limits on the amount of recovery that would go to attorneys' fees. That also can vary a lot, usually on a sliding scale. In North Carolina, for instance, attorneys would get 25% of the recovery up to $10 million, and then 5% for damages over $25 million. In Missouri, for instance, it's quite different, where the range is from 2% to 15%, with a total fee cap of $10 million. So quite some variation there. So these have been enacted at the state level to address agreements. And as localities have become more active plaintiffs, I think we can probably imagine that these statutes could be brought in to apply to them as well. Most recently in Texas, in 2019, there was passed legislation that gave the state attorney general a check on the ability of localities to enter into contingency fee agreements. Typically, they would have to disclose the terms of the agreement and allow the attorney general to scrutinize it and make sure that it is in the public interest before they can actually make that contract enforceable. And that has actually been used several times. It's not just it's not just a theoretical piece of legislation that's there. It actually has been used by General Paxton. Another dimension to that legislation is that it allows the Attorney General to reject the agreement if the subject matter of the litigation at issue would involve a matter of statewide public interest, in which case the Attorney General can say, well, look, this is something that my office is either involved in now or is going to be involved in, and therefore localities should stay out of that. So that's another trend that we're certainly seeing as states and localities engage in a bit of a turf war to figure out who is going to be taking the lead on these matters, but I think that's properly the subject of a future panel, so I will leave it for them. There are other ways that states might want to reduce incentives, if they were so inclined, to reduce the incidence of localities bringing litigation. The U.S. Chamber Institute for Legal Reform has put out some good research on that, and if there's time, I'm happy to discuss what those incentives might look like. Thank you.
Very good. Thank you. Next on the panel is former Mississippi Attorney General Jim Hood. He was the Attorney General from 2004 to 2020. Before then, he was District Attorney, and one thing I'd like to thank him for now is prosecuting people involved in the murders of Goodman, Cheney, and Schwerner. Having been in college at the time and having friends going down there, brave friends, that was a very important prosecution. But that will be the subject today. Please give us your thoughts.
Thank you, Judge, especially for your kind words. I I'm glad to see people are from here all across the country. You know, I got to admit, driving from the hills of northeast Mississippi this morning, I was concerned that there would be a large crowd of Tennessee fans. You know, a couple of weeks ago, Ole Miss fans got water bottles thrown at them. So I was just going to make sure we didn't have a lot of upset Tennessee fans. I served as an assistant attorney general under Mike Moore when tobacco began. Then I went to Oxford, Mississippi, and I was DA of 7 counties there for 8 years, and then came back to the AG's office in 2004 and served 16 years as AG. So I looked at the decision whether to bring litigation with outside counsel or try to use our own in-house lawyers as just cut and dried. You know, what's my duty? How do I achieve it? And so looking at it as just like I did as a prosecutor, has some company or individual done an act that has done damage to the state? And if so, how can I best bring that person to the bar of justice? And in a state like Mississippi, you know, we had 135 lawyers, which seems like a lot, you know, but it's not. Because you got 10 at the Department of Transportation, 10 at the Department of Human Services. They're spread out at all these different agencies. My civil litigation division had about 8 lawyers in it. And they were primarily for putting out fires in federal court when the state was sued for injunctive relief often. And we had 0 budget in the Attorney General's office. And I dare say that the vast majority of Attorneys General offices do not have a budget to support litigation, especially on large-scale litigation and these cases that last for a long period of time. So, you know, without a budget, I just call balls and strikes. Was it best to go with outside counsel or try to do litigation in-house? And, you know, when tobacco began, I got to admit, I was assistant AG, and Dickie Scruggs and some of those lawyers that brought that case to Mike Moore back then, they had a novel theory, you know, and it was nuisance. And it was that the fact that it's not, you know, all the smokers lost all of their cases, individual cases, but they'd pick up a document here and there. And they were feeding them to lawyers. And when we began that litigation, I wasn't really that supportive of it. I thought, you know, these tobacco companies will run you over, Mike. You know, this is a dangerous litigation for you. And it was the right thing to do because Congress was frozen. The White House, I remember trying to get Al Gore on the phone, you know, because we were in the middle of settlement talks to try to get the White House engaged. Congress was frozen. Nothing would happen. Had it not been for attorneys general in this country, that litigation would have probably occurred, but I don't know if it would have occurred way back then and had such an impact, you know. For those who, I see a lot of gray hairs out there like me, you know, you used to go to restaurants and there were people smoking. You know, if you go to Europe now, it shocks you, you know, if you go to some places in other countries where they still do that. And so it had a huge impact on our country, and there was no other way to do that. Now, you know, with small states with no budget, no ability to bring these cases, what I did is I took it on a first come, first served basis, sort of like it was a lawyer's intellectual property. Generally, a lawyer that brought a case to the Attorney General's office, they had individual claimants. They understood it. They had scientists already on board. They understood the case. So whomever brought it to us first, and it was a public record because they would have to email me or my chief of staff, and we gave it to them if the case was good, and we scrubbed them really because I mean, we couldn't manage that many cases. So we were very careful in what we chose to cases we chose to bring. So the process is the contract would be entered. It was one contract for everybody, no matter whether they were a campaign contributor or an enemy. And if they were an enemy, if they had the capability to bring one of these cases and the money to finance it, we let them have it. And so there were some defense firms that brought us cases. Now, a lot of times they would associate a plaintiff's firm later on in litigation, but those cases were, you know, decided on a case-by-case basis by assistant attorneys general. Originally, I think, probably more Democrats hired outside counsel than did Republicans. Now, if you look at the opioid litigation, it's right the opposite. Because I think, Republicans have realized that, there's a term used a lot previously about privatization of government. I mean, that I've laughed often because I was a Democrat in a state, I represented 7 statewide elected officials who were all Republican, and the legislature was all Republican. I laughed and said, well, I'd call it privatization if I were a Republican, and it would be okay to hire outside counsel. So there's kind of been a shift there, but if you look at it and you have transparency, where you have the contracts like we did online, people could look at the contracts and they knew, we didn't do RFPs because a lot of the time you didn't want the companies to go sue you in another venue. So we put them on public record at that point. In BP, I used hourly basis because I knew we were going to get paid. And the legislature backed me up. They paid it. So I did an hourly basis on BP, and Luther and I worked together on that case. So there's some instances when you're going to recover, but some of them are long shots. Take WorldCom. They were a Mississippi company. You remember back when I first got elected in 04, around 05, they were bankrupt and they were in a merger. It was a long shot. Had it not been that they were being purchased by Verizon, they probably would never have settled. And that was a case that it was in bankruptcy in Delaware, somewhere, I can't remember exactly where. But our office just didn't have the capability of bringing those, and that brought us $100 million is what the state recovered in that litigation. And Standard & Poor's was one of the cases that I brought. Richard Blumenthal's a senator now, and he was the first and I was second in Standard & Poor's. That was a case that they were a credit rating agency, and they portrayed themselves as being pure as a driven snow, when in fact they were approving those tranches of mortgage tranches that created our economic collapse in 2009 and 10. And we brought them in. The Department of Justice later on came on board. But had it not been for some law firms that had the capability, securities firms in particular, there are not that many, there's not even one in Mississippi that does that type of litigation, we had to hire on. On the issue of cities and counties, I differ with Mike Moore, my predecessor, on whether cities and counties should have authority to bring litigation. Local governments, I think, should be able to. It does create problems in working out settlements, but our government started in forts, and I think the local municipalities and counties, they didn't get any of the tobacco money. So they're aware that the legislature is not going to give them any of this opioid money, and I think they had losses, and they spent money for ambulances to transport people who were overdosed to try to get them to treatment. They spent money on all these type programs, and they should be able to recoup that. The issue of campaign contributions by trial lawyers who represent attorneys general or local governments. I fought that battle quite a bit in 4 campaigns for attorney general, and the people in Mississippi, they got it. They understood that if I were to unilaterally disarm, take no money from lawyers, primarily lawyers are all that are concerned about the attorney general's office and what that office does. If I were to not take any contributions from any lawyers, then we would concede the office. And so lawyers have the First Amendment right to support those, just as long as there's no quid pro quo, you get a case. That was not even possible under our system. One last thing, I think I got a minute, is that I worry about our country. If we restrict the courthouse to the working people of our country, that's the one place the little person can go fight. And there's plenty of restrictions out there right now in contracts and statutes and so forth. We're entering into a time in our country, as Shakespeare said, I think it was Henry V, the first thing we need to do is kill all the lawyers if you want to take over. And I've kind of laughed about that until I went to Turkey. When Erdogan was taking over in Turkey, I met with lawyers, I met with people in the media, and I saw what happened in that country. And to think that it wouldn't happen here in our country, if we take the courthouse away from working people and restrict those rights, it can happen. And during Katrina, we think we're so civilized. You let that power go off for 3 days. Good, honest people will steal gasoline. You know, and our country is at a volatile time. And I think we have to pay more attention to the rights of working people and small governments to litigate their issues before the bar of justice, rather than us having a top-down strategy of preventing them from having access to the court system. Thank you.
Thank you, Jim. He pointed out to me at the beginning that he's at the far end of the table, so it'd be hard for me to stop him from adding a minute at the end. But that was fine. Next, we have Luther Strange. He has his own firm in Alabama now. I was so pleased when he came up and introduced himself this morning and smiled, because this man was dealt, I think, a pretty lousy hand a couple of years ago. He had served as the Attorney General of Alabama from 2011 to 2017. Then he was appointed to the United States Senate, and he's the man who lost in the primary to Chief Justice Roy Moore. I'm sure most of you remember that story. But and then Moore was exposed shortly before the general election. Might have helped you in the primary. I don't want to get into politics too much, though. But I think we can all agree about Roy Moore. So give us your perspective, please.
Thank you, Judge. You're giving me indigestion here this morning talking about terrible flashbacks. God, I'm a recovering politician. I might start shaking here. No, I really appreciate the opportunity to be here with you this morning, with friends on this panel, and Judge, to get to meet you. Jim and I work side by side, neighbors and friends and colleagues in the Deepwater Horizon case in the Gulf of Mexico, which was probably the biggest case that I handled during my years as Attorney General. And I learned a lot, and it's given me a lot to think about that relates to this panel. And really, what I see is a tremendously challenging period of time for not only AGs, local officials, people that hold the office that I held, but for judges and for legislatures, federal and state judges, as to how we get a handle on some of the cases that are going on. It troubles me, truthfully, for the current state of our tort system. And I'll tell you why I say that and cover some issues, and then talk a little bit about my rules for hiring outside lawyers. And I look forward to your questions as well. You know, traditionally, the Office of the State Attorney General has been the representative of the people. In Alabama, it had massive, broad authority. I think Jim had the same authority in Mississippi. All criminal powers to prosecute every criminal, superintend cases from DAs to the chief prosecutor in the state, all civil cases, all appeals, massive power. And it always was with the view of representing all the citizens of the state. And typically in large cases involving harm to our citizens, it's all about justice for our citizens, we would look to our colleagues. It was a national case, and we would handle it in a system that seems antiquated now, but it was called the multi-state system of resolution. So all the AGs would get together through the National AGs Association or through their own friendships and say, there's a mortgage crisis, we've read a lot about it, we know a lot about it, there's some experts on this issue, our citizens have been impacted, let's open an investigation, a multi-state. The state AGs, pooling their 50 offices plus territories, would come up with an executive committee, would, if necessary, but very rarely, hire an outside lawyer, because when 50 state AGs come to Wells Fargo, just to pick on them, and say, we think you've been guilty of fraud, and here's what we plan to prove, and we'd welcome your cooperation. If not, you're going to be facing a lawsuit from the entire state. That gets a company's attention. When you come into court on behalf of the people of the state of California or any other state, that changes the ballgame entirely from a private lawyer coming in on behalf of an aggrieved citizen. The multi-state process worked well for a long time, not perfect. We've evolved a little bit from that model with the introduction of MDLs. And I'm going to put tobacco aside, multi-district litigation. Judge, the federal courts are now getting swamped with MDLs that take on all kinds of issues. And now I'm going to introduce another factor here, novel legal theories. So let's just say global warming is an issue. It's clearly an issue in this country. The legislature, the EPA, other people are wrestling with it. It's become an issue in the courts. Federal courts are dealing with the issue. The claim is brought using novel theories like public nuisance. Does that apply to global warming costs that we have to incur on our coastal community? And we're going to handle it in a case that's going to bring plaintiffs from around the country into one federal court to try and decide that. That might be brought originally by AGs, but let's say the city of Los Angeles or somebody else wants to also weigh in because they're actually incurring the harm. That's their claim. Then you have an MDL with state AGs and municipalities in one federal court somewhere in America trying to deal with the issue. That injects private lawyers and that injects cost and other things. And that'll get me to my, that's the path we've sort of been heading down to, even to the point that some defendants are finding that with all the plaintiffs that they're facing, state AGs, municipalities, private attorneys, AG's offices and their staffs, there's not any way to ever get into one venue. It should be the MDL. Maybe it is in some cases, but it's gotten so complex, so many parties, so many novel claims that they say, I just want to settle. Can I just please settle this case? And they say, well, we've got so many parties here. It's going to take a while. We're not sure. The cost just starts running and running and running. And so you're even seeing companies now go to bankruptcy court. I can't even function in this MDL anymore. I'm going to just declare bankruptcy and go into that case. Now, there's some precedent for that in the asbestos cases and others. So it's not totally unusual. I'm just seeing a path that we're going down. And I raise that because as a practitioner and as an attorney general, lots of things are implicated there. And I'm really talking as a former attorney general here at how I would like to see these things work, because I'll use the Deepwater Horizon case as an example, but back to private attorneys. AGs have always used private attorneys for their work. Typically, before AGs got involved in so many civil matters and national civil cases in the tort world, mass torts and so forth, you know, they were the chief prosecutor, the super DA. The biggest murder case 30 years ago in Alabama was tried by the attorney general. You know, that was their claim to fame. That's what they focused on. That has totally changed in the last 30 years, and tobacco gets a lot of the credit for that. People are much more interested in national civil issues, and the AGs you see now come from major, you know, firms that have been involved in high-level litigation because it's so important. But hiring outside lawyers was not unusual in those days. Typically, though, for like a right-of-way question or something that was just sort of an oddball, an HR question or something like that, not major trial litigation. That is relatively new development. In my experience, I had basic rules on hiring outside lawyers. Jim did a really good job of that. My rule was, unless I could stand up in front of the citizens of the state and say, I'm going to hire this firm. This is why I'm hiring them, because obviously we can't do it ourselves. This is how much I'm going to pay them, because you are paying for them. The citizens are paying them ultimately. This is what I expect to get for what I'm paying them. And this is the transparency related to that. If I couldn't stand up and say all those things, you know, in public, then it probably wasn't a good idea to hire them. But as I've thought about the road we've gone down now with the injection of the private bar representing so many states, with the novel theories, I've come up with my 4 C's of hiring outside counsel. And they're not necessarily original, just ones that seemed to rhyme when I started thinking about them. One is control. If you're the Attorney General, you know, and you've sued someone in a big case, any one of the cases we've discussed up here, you know, you want to know who's going to walk into court and say, I represent the people of the state of Alabama. So if it's not going to be me or someone from my office, I'm turning it over to someone else to speak for the people of my state. That's a very serious issue, because that, it'll feed into the other C's that I have here, but that's the power of the AG. So if the cities and municipalities decide, well, actually, I was harmed by that same conduct. So it's the same cause of action. It's basically the same harm. It's just a subdivision of the state. And I just feel like I need to be in this case, and I'm going to hire a lawyer to represent me, the city of Birmingham, in the case. So I go into the judge's courtroom and I stand up and say, I represent the people of the state of Alabama, Judge. And I turn around and somebody stands up and says, well, I represent the people of the city of Birmingham. Well, I've got the same claim and the same damages. It's just a mini part of that. The judge says, well, anybody else here from Alabama? And 15 other lawyers stand up and say, well, I've got a claim, and I've got a claim, and I've got a claim. That's an issue in terms of managing a complex piece of litigation. And if you multiply that by 50 states, 50 AGs and subdivisions in a federal court somewhere, you can imagine the complexity of that. What are the claims being brought? The claims are important. Typically in AG's offices, you know what the claims are. It's in a state statute, and it says this is some sort of consumer protection issue that they're very well grounded in handling, because our citizens are ripped off all the time by con men and others. Hurricanes are the worst. When they hit, or a tornado hits in Alabama, the scam people come out of the woodwork and we go to work. But if it's public nuisance, if you say, well, this conduct is a public nuisance because it's out of favor, or it's something that's not being addressed by people that should address it, like the Senate or somebody in the federal government that has responsibility for that, and we're going to have to address it ourselves through the court system, you're going to ultimately maybe get a decision from a court, and that's going to set a precedent. And that precedent may come back to bite you if you're not, back to my first point, in control of the case and understanding where the precedent's going to go and how that's going to ultimately affect things. What are the costs going to be to the state? Contingency fees are not unusual. There are a lot of rules about hiring people and how much you can pay them. And that's for the legislature and people like that to decide. You have to make a decision as an attorney general, what's it worth to you to do that? There are pros and cons, which leads to my third C, which is conflicts. And that's one that worries me a little bit, as I've seen some of the cases proliferate, where you go into a federal courtroom and there's 50 states and there's hundreds of thousands of municipalities and there are dozens of lawyers. I might be representing a state here and a municipality over here on the West Coast. And it starts to get a little complicated there as to what my incentives are or potential conflicts. That's getting to be raised in some cases. I don't know how it's going to play out. I can just see it as an issue, and what I'm trying to do here is flag some issues. There's some, I hate to go to places where people talk about, I see my time's just about up, and I'll get to this in questions, Judge. I've got some ideas about how to solve some of these questions. I don't want to just give you all the problems, but these are issues that we're all wrangling with here, and they're ones that ultimately our citizens are going to wrangle with when they look for results. So thank you.
Thank you. We'll spend a few minutes within the panel questioning each other. I know, Trevor, you said you would hold back on some of your ideas about the hiring and pay of outside counsel, and then well, you just said you have some responses to give to that too, Luther. So, but all of you can participate. But why don't you go ahead, Trevor?
Sure. I think what I was referring to was some possible ways if state legislatures, state AGs pushing for these reforms who are intent on keeping control of litigation at the state level, ways that they might disincentivize localities from bringing suit. And it does have to do with the potential financial recoveries that might be available to them. We heard Professor Mahoney talk in the last panel about the municipal cost recovery rule, which is of varying strength in different localities, depending on how judges have interpreted it. But states, for instance, could codify that rule and make a whole set of funds inaccessible to localities who are trying to seek recoveries. You could put caps on punitive damages that are available. And then you get into the more sort of traditional tort reform options that state legislatures are pretty familiar with. So there's just a couple ideas that came to mind. I'm sure there are others, but I think it's something that state AGs are increasingly dealing with and thinking about, whether it's in the context of the opioid litigation or elsewhere. General Yost in Ohio, tried to face down some localities who were whose cases were ahead of his in federal court, and asked the Sixth Circuit to prevent those trials from proceeding, and put forward this idea that it's his role as the state AG to represent the people. Only he has the parents patriae authority to represent them, and that's something that's being litigated. He was unsuccessful in that. The Sixth Circuit denied his petition for mandamus, although arguably it was based on the strict standard for getting a mandamus granted. But it's clear that AGs are thinking about this. And another question for the group is what we see as the likely lessons or outcomes or takeaways from the opioid litigation. I think that's one of them, is a growing realization by localities that they may have a role to play. We can debate whether normatively that is a good thing, but I think it is a reality that they feel emboldened to bring suit, and time will tell how states respond to that.
Robert, you're...
Well, it's like listening to the last panel. It kind of blew up my presentation because there was so much there. Yeah. But just listening to that, I'm getting all guilty because I represented Cook County and Wayne County on their claims, and we lost both at the Supreme Court because they flushed it, and Wayne County was a home rule county, and they said, state money, state does what it wants, you get nothing, sorry. And now I see the opioid stuff, and some of the courts are coming around saying, well, no, they should get a share, and others are just recognizing that it's sort of a political solution, that states are more accommodating. If I recall correctly, and maybe Generals Strange and Hood can correct me, but I think there were a couple states back in the tobacco days that did actually give their county some money. They shared it collaboratively and voluntarily. But let me step out and just talk about the fees associated with those things, because everybody said a lot about fees. And all of the problems are arising from tobacco. There's no question, right? All of the discomfort with private counsel came from tobacco and the enormous fees people got. And my firm represented 12 states. There were giant fees. And it happened for two reasons. One, first, suicide was the only outcome I saw on tobacco at that time. Like, I just thought it was a suicide mission, right? I didn't think anyone realistically thought anybody would win those cases, and certainly not get $256 billion. So there was no oversight and really no prior experience for that kind of suit in negotiating fees. But I think that's done. I think it's fixed. I think attorneys general negotiate hard. I think they understand what's out there. They understand what the market is. They talk to a bunch of firms. They have better procurement processes. And Arizona adopted a statute that's a sliding scale, and it cannot exceed those. And they're not, by any means, they're not lavish. But the lawyers that do these don't just want the money. They want to do the case with you, because it's exactly what General Strange said. It makes a difference when you walk in with the state. I'd walk in with what I would deem today a crummy theory, and they'd go, oh, Mr. Carey, that's a fantastic suit. We better get discovery going immediately. And then flash forward to me as a private lawyer, I walk in what I think is an awesome suit, and they're like, come on, that's terrible. Like, yeah, take that home, right? It's just different. They want to help you if you're the state, and it makes a difference. But I think the fee issue, to me, if you've got a statute like Arizona's, which a lot of states have adopted, it solves the problem. The bigger risk in my mind is some of the hourly people who get paid, where states let them come in and bid their hours, and they put in $600 an hour or whatever, and then the state's stuck with them because they're the only person on the contract, so you end up paying way more than anybody would want to pay. And in Arizona, what we did, Grant Woods, when he was there, we just flipped it. We said, this is in $1991, you can't make more than $135 an hour. So you're not doing the big cases. You could get some work, and it could help you fill some of your young lawyers' experience needs, but it's $135 an hour. Don't bid if you don't want it. So I just think the fee issue is grossly overstated these days.
Jim, you talked about it in Mississippi. One thing that surprised me, you spoke of it in terms of plaintiff's attorneys, but in a lot of states, at least in New Mexico, I assume it's common, a lot of the outside counsel are defending civil rights claims and things like that from the risk management division of the state. So this is not a plaintiffs versus defense bar issue, I don't think. But you said you were protected. People understood that attorneys could make political contributions because you couldn't do much about their fees or something. What are the protections in Mississippi?
There were, I've forgotten, one time I figured out how much we paid private attorneys by the hour to defend the state. There are a lot of large law firms that the state, it's not just plaintiffs lawyers that AG's office hire. And it's just a question for the legislature. Do we want to pay a lawyer $300 an hour who is capable of handling a securities case? I mean, an annual salary at that rate, or $600 or $1,200. And I say no. I mean, I think we're better off to use the best lawyers for those type of cases, particularly those who have an individual case. And in Mississippi, I kept the fees before there was any legislation. Back in 2004, at 25% max, and it went down on how many million that were recovered. And the legislature subsequently, the Sunshine Act that one of y'all mentioned, was passed in several states. They passed something, and of course they were kind of critical of me for hiring, but I had one contract on the internet, everybody to see. And come to find out, they actually pay the lawyers more than my contract did. It allowed a little bit higher percentage, but it's not always a high percentage. I mean, in opioids right now, the projection is under the MDL that the pay will be from 5 to 8% if you're paid from the MDL fund. Waiters make more than that, but of course it's a lot bigger bill too. But some states are setting up supplemental pay for lawyers to get, their contracts are 25%, a lot of them, some 33. But they're setting up a supplement to get it up to 15%. Judge Polster in that litigation has capped it at, and he didn't cap it at 15%. He just said, 15%, anything over that would be considered unreasonable unless shown otherwise. So the percentages are not that high now. In tobacco, there was, at least Mississippi, we were one of the non-settling states, original states that brought that litigation. There was, the tobacco companies picked a judge. It was actually a judge. And the plaintiffs' lawyers picked a judge. And then those two judges picked a judge. So it was a 3-judge panel. And Greg Zeller's here, my great friend from Indiana, was AG and a gentleman lawyer there. I think it was held in Indiana. And so the fees were decided by a 3-judge panel, at least on the Mississippi case.
And you wanted to say additional things, but let me add one question to the mix, which I don't think anyone has addressed here. Maybe I overlooked it, but we're talking about fees for attorneys to litigate. And what Professor Fitzpatrick pointed out, well, several members of the prior panel, sometimes the public interest might not be in a lawsuit for damages, but perhaps regulatory issues or injunction or something like that. How do you make the decision whether to proceed in that way as opposed to outside counsel litigating?
That's a great question. It kind of goes to that control and conflict of interest points that I made on my 4 C's there, because outside counsel wants to litigate, and the financial incentives are very strong there. When it can be injunctive relief and other kind of things if you're just sitting in the AG's office, not motivated by that. There was some discussion about incentives. I don't think that it's necessarily a good idea for an AG to have that financial incentive in terms of financing his office. But I know Jim had the same issue probably that I had. You can't trust the legislature, and that's why victims are very And you can tell them I said that if you run into any of them, because they are very difficult to work with. And that tobacco money is a good example. Money that you get for your victims, oftentimes if it goes into the general fund, is used for some other purpose than to reward the victims. So we always tried to make sure that all the relief was focused on them. And the legislature is a tough problem. But you also create a perverse incentive if you're relying on civil recoveries or penalties in criminal cases to fund your office, because that just creates a perverse incentive that's unrelated to the merits of the case.
Let me, if somebody has something particular, I'd like to turn to the questions here, but do you want to add one thing, Trevor?
Picking up on something Rob mentioned, when you said, Rob, that you've had strong cases that you brought on your own that didn't get much traction, but that when you're with the state, immediately people start paying attention. And in those, sometimes those cases might not be nearly as strong. And I guess the question is for the AGs, when you're thinking about whether to allow certain cases or to bring certain cases, how do you evaluate your own credibility? I mean, if the incentive is for, if an outside counsel comes to you and says, I've got this case, what do you think? And the response is, yeah, run with it. No harm in running with it. How do you make sure that you keep your credibility? And I guess it's a question for AGs, but also, you all are obviously very responsible leaders. You certainly have a lot more experience than the typical city and county leader. So how do we make sure that cities and counties who are bringing suit only bring cases that are meritorious or that have some promise of merit?
Or if I can merge that with one of the questions, I'm sorry I'm so technologically challenged, but the question just appeared on this device in front of me about 3 minutes ago. But one of the questions had to do with, well, what and maybe I'm paraphrasing a little bit, what about making sure that it doesn't lead to misinterpretation of laws, or in some way this suit might win, but in the course of winning, it'll create policy contrary to what your office would otherwise pursue?
Well, I'll go first. I'll just hearken what General Strange said. The AG is in control. They have to be in control. They have to keep their eye on the suit. And in my case with General Brnovich against Mercedes, they're very active. And they do what they want to do, and we follow their instructions. If you do the opposite and you let the private counsel run with it, yeah, that's not good. That's not a good situation. But realize, you're talking about a pyramid of sorts of unremedied wrongs. And we're not talking about taking garden variety junk cases to the AG. You're talking about the best of the best, where there's big dollars, big wrong. It's something the AG would be proud of. The AGs don't want to go do, and federal courts don't want to do, hyper-technical problems, right? They don't want to go do the one where the federal regulation says the tail lamps have to be on when the headlights are on, and this car doesn't do that. That's not something you get up in the morning to do, right? You want to care about the case. And so you want to see the good ones. And the opportunity right now is huge because of the arbitration rules. Private lawyers are barred from basically any situation where there's a written contract, because any competent corporation will have an ARB clause and a class waiver. AGs can solve that. And so people like me and my firm and firms just like mine have a huge inventory of cases that they wish they could do, that if they could go to the AG and just say, look, it's your call, you decide, but this is an unbelievable case. Can you do it? Like DoorDash, the company that takes food around, was taking tips and using it to supplant minimum wage payments before they gave anything to the employees on the tip. Okay, that would be filed tomorrow, and they'd lose probably faster than that. But you can't do it right now because of the ARB clause. So there's a bunch of opportunities, and I think AGs just have to wrap their minds around about how to leverage outside counsel if that's a choice they want, but they should at least take advantage of the opportunity to review the cases.
I had the question about how do you keep municipalities or local governments from filing litigation that maybe the state hadn't done. I think the market will control that. Most all the cases that I've seen where lawyers go to local governments, there's already an MDL. You know, it's a shoot them in the barrel case, shoot fish in a barrel, you know, it's a southern term, but anyway. Easy case, and so I haven't seen that many. I saw it in BP, and we worked ours. I thought it was going to be a problem with the state working out the share in BP with the local governments, but it really worked very well. Because you know they were damaged by it economically and some physically. The ones
did it work out well because it wasn't in court? Because judges don't want to hear from 20 people. That's why in motions to intervene, if your interests are already protected by counsel in the case, you can file an amicus brief, but you're not going to participate in court. Did it work because it never got into the courtroom?
We had a wonderful judge down there, that had patience with the lawyers, and that was an exceptional team. Opioids, there were some good teams, but it was much larger. I mean, there were only 5 states in the BP litigation, and the judge took the time to listen and bring people in, and it was an unusual. I got to admit, that was an unusual type case. But as far as cases in the future, like opioids. I don't see municipalities, just because some lawyers are going to recover 8% or whatever it is, that they're going to be knocking down doors to bring litigation on behalf of cities, because they're, unless an AG is already out front creating a headwind, then or tailwind, whichever. But I think the market will dictate those cases in the future.
There's a very interesting question here that I don't think anyone's touched on. What about the practice of foundations placing lawyers in an attorney general's office? How do you respond to that practice? If it's going to occur, what sort of controls? You don't like that?
No, sir. I would take their advice and counsel and appreciate it. But as far as having one and swearing them in as an assistant AG and allow them to argue on behalf of the state, we didn't usually do that.
We wouldn't do that either. Yeah, that's a bad idea.
No support here. Well, that's your answer if all 4 of them agree. Okay. I think these other questions, maybe someone needs to raise his or her hand, because I think the other questions have been covered. They were submitted earlier in the program. I hope I'm not overlooking something. So we've got a few minutes. Why don't you each sum up all the wisdom you can provide in a minute each. That includes you, Jim. You want to go first?
Well, thanks, Judge. Yeah, again, thank you for the opportunity to talk on this very important subject. I hope that Jim's right, that, and I think you are right on the municipalities, that the market is going to correct this a little bit. You won't see municipalities unless the AGs are already in it, and that may work out. On the complexity of having so many lawyers with novel theories representing cities, states, and counties, and everyone else under the sun, the market may work that out as well, and I hope that it will, because efficiencies are what make the judicial system run. Judge, you mentioned you don't want to have 10 lawyers stand up and say the same thing, and the cost will follow that, and we did that in the Deepwater Horizon case. We all handled it differently. In our case, we decided that we would handle the litigation ourselves. We weren't equipped to litigate against a major international company, but we formed an alliance with the federal government, with our sister states, with the private lawyers who had already invested millions and millions in a war room and everything else. And we said, we'll take the benefit of what you've done. You'll get the benefit of our standing next to you shoulder to shoulder in court as the state and all the people of our state, which is very valuable to you. And in the end, based on the fee that my predecessor had signed, we saved about $140 million. And we actually applied to the court for our own office's work, which was available in the common benefit petition, and we got $10 million for our good lawyers' work. So there are ways to be creative and think about this. It takes some creative thinking here, and I'm hoping that our AGs will be on the forefront of that.
Rob?
I think that I think attorneys general will start looking at the budget they have and how to get to the point where they're maximizing their impact for the state. And that will take some rethinking of how you staff cases and how you use outside counsel. And it'll have to be preceded by getting the incentives right, the fee structures, because there's a way to do it where it makes sense, where it's not a political risk or an embarrassment, and it's a fair fee. You just have to get those right. And the other part is on the structure on revolving funds, which was the question about where does the money go? Well, at some point you have to have a revolving fund that allows you to keep some money from your recoveries as an AG's office so you can fund your lawyers on a going forward competent basis, meaning not year to year where they come in and raid. You have a great year and you bring a big chunk of change in for the state and then they deplete it because they have other needs for it, then you're broke and you can't go do another case. They have to get that resolved so it makes it work. And then I would say again, my last point on the arbitration thing, well, there's a lot of work out there and a lot of opportunities, and it's not that the private lawyers are great and better than everybody else, but they have their ear to the ground. And if you don't believe me, just go look at Pacer or Law 360 and look at the cases that get filed by the top tier gold standard firms in America and compare that to the cases filed by states that are of comparable size. There are just too many people with too many insights and too many tips on wrongdoing. And those are people that you can tap to protect the citizens of your state if you're an attorney general.
Trevor?
I think it remains to be seen what the market will look like in the next few years, and a lot will depend on the outcome of the opioid litigation and the lessons that people draw from it. Tobacco is supposed to be one of a kind. I think that might have been Richard Scruggs who said that we're never going to have another tobacco. People are perhaps legitimately comparing the opioid litigation to tobacco and causing people to wonder, well, what's the next opioid or what's the next tobacco litigation going to be? And I don't know that plaintiff cities and counties are wanting to go back. I mean, you do have some large cities who have their own affirmative litigation departments, and they might be pursuing these regardless of what the market says. On the other hand, you have smaller localities who are not initiating suit themselves, really, but having the case presented to them by private counsel. So I think a lot remains to be seen about what's going to happen with respect to the lion's share of municipalities across the country.
You want to add a minute?
Lastly, I think we might need to look at changing the rules on MDLs, diversity rules. We have plenty of state courts. Most AGs, most private lawyers, I guess, would prefer real lawyers, ones that will litigate a case, would prefer to be in state court, and we have much more ability there. It's been as a matter of convenience for the defendants oftentimes to bring them to federal court, where they're almost unmanageable when you have that many there. So maybe we need to take a look at that. And as far as Dickie Scruggs' statement about tobacco, there's another tobacco, and it's called Juul. That's the company that, I think Altria, after all the fight that they had in tobacco, they go buy Juul. And they're addicting kids all over the country, and it's creating havoc for schools. So I suspect we'll see another round of similar litigation. I don't know if it'll be quite as big financially.
I have one new question. Whoops, it just went off. But this could be answered by raising your hand, but I'll probably get the language wrong. Have any AGs used investors to support state litigation brought by the state? Do you know of any example of that?
I'm not aware.
Okay.
I'm not aware of any.
Well, I enjoyed this. Thank you very much.
Thank you, Judge.